Hi, I'm Joe Gailey, and I want to welcome you to this educational webcast. Today's subject is, should I incorporate my business? This is a very common question that I get and others like me get, and we're going to have multiple presentations on this. There are basically two reasons why one should incorporate their business. One is for liability protection, and the second is for tax purposes. In this presentation, we're only going to talk about liability, and there'll be another presentation on this subject to talk about taxes. So let's talk about liability. If you were a self-employed person, then you are liable for your own negligence, and you're liable for the negligence of those people that work for you. Now, incorporating your business, which can also include using the form of an LLC as a business venture, which is today perhaps the more preferred vehicle to use. I'm going to refer to all of this as incorporating in a generic sense. If you incorporate your business, then you are still liable for your own negligence, but you're not liable for the negligence of your employees. Now, let me give you an example. Suppose that you're an electrician and you go to someone's house and you wire the house, and for whatever reason, you got the wires crossed and it caused a fire and the house burned down. Well, you did the work. So you are eventually liable for the damages. You may have insurance to cover it, but eventually it's your liability. But if you were incorporated and you sent your employee and they did the same thing, then the employee is liable because the employee was the negligent person. The corporation is liable because they employed the negligent person. But you individually are not liable. Now, there's a lot of misconceptions I've found over the 40-something years I've practiced law and accounting that you incorporate, and that means that you're not responsible for any liabilities, and that certainly is not true. You can never not be held responsible for your own negligent actions, whether you're incorporated or not. But you can be held liable for the negligent actions of other people. Now, with that said, there are a lot of exceptions to the rule. Let me tell you some of the more common ones. One is that if someone happens and there's an injury, a damage that's done because of your business, even though you weren't involved with it and you weren't personally negligent, the injured party may claim that you were negligent in hiring the person who did the work, or that you were negligent in retaining that person after you had knowledge that they did sloppy work. So, for instance, if you own a restaurant and it's incorporated and you're delivering food to customers and there's an automobile accident during the food delivery, well, you weren't driving the car. You're back at the restaurant. The person that was driving the car was employed by your corporation. The car was owned by your corporation. Generally, the corporation is liable, the employee is liable, but not you personally. But suppose that the circumstances were such that they could allege that you knew this particular person was a lousy driver and you allowed them to deliver anyway. That would be called negligent hiring or negligent retention. So even though you're incorporated, there are ways that you can be brought into liability. Secondly, is that there are some federal statutes that ignore corporate liability and make the individuals liable in certain areas. For instance, the Federal Labor Standards Act, FLSA, which is the law governing minimum wage and overtime has a provision where the government, the Department of Labor, can name the individual owner as a joint employer and make them personally liable for overtime violations, even though they may not have been involved with it or even had knowledge of it. So in that case, incorporating your business will not shield you from that liability. There's also under the Title VII Civil Rights Act, under the discrimination employment statutes, there's a similar provision providing for joint employer, where someone may be named as a joint employer individually, even though they were not involved in the actual discrimination or harassment or the events that gave rise to the claim. And finally, there is always the issue of piercing the corporate veil. And that's based upon the situation where a person does not give proper regard for the corporation. They commingle their assets in it. They write personal checks or write business checks, corporate checks for their personal expenses out of it. They don't keep minutes. They don't do anything that a normally prudent business person would do. And if so, then they can conceivably become liable for the corporation's debts. Now, in most states, it's much harder to make someone, to pierce the corporate veil and make a shareholder liable. Georgia is a little bit easier, but it's not easy. I don't want to let you think that it's a slam dunk that you can be liable. It's still difficult, but it's not as difficult in this state as it is in other states like Mississippi. So incorporating or setting up an LLC for your business can never hurt you. It may help you, but it's not a panacea to avoid all of your potential liability issues. Thank you for joining us today. If you have any questions, please send me an email at the email address shown, and we'll try our best to respond to them. Please stay tuned to our next installment where we talk about the taxation of companies that incorporate. As always, these are complicated subjects, and one should always not rely upon this webcast as your sole means of making a decision, but meet with some knowledgeable professional who can analyze your particular circumstances and make a recommendation as to what you should do. Circumstances can change decisions. These things are highly circumstances based. Thank you for joining us and have a great day.